Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, hit that like, share, and subscribe button. There's a PayPal link down there for anybody that wants to share some love. And, of course, the StreamYard link is there for anybody that wants to join the panel. We're going to go over the Health and Human Services Estate Recovery Program tonight. Just a little overview. Information that I've got on the internet, and the links are down in the details section for anybody who wants to check them out. These particular links are for Iowa, but every state has an estate recovery program through the Health and Human Services. This is the estate that's set up through the enumeration at birth. It's their estate, and they're wanting recovery for the services they provide. However, there are certain conditions, if you know of, that you can avoid those payments during your lifetime, as they are payable upon death due to certain necessities of life. So we're going to get into it with the first document. And again, like I said, this is from Iowa, and you can search this stuff up in your own state. It would be Health and Human Services Estate Recovery Program, and then your state. This one here, this is a basic information page that says important information for you and your family members about the estate recovery program. And what I'm going to point out here is the very specific language that it uses that tells us certain things have already occurred according to the plain writing in these government documents. And understand the language I'm using. The words are very specific, folks. And in this document, which is a government document from the Health and Human Services, Iowa Health Link, Iowa HHS, Health and Human Services, says Iowa Medicaid is a government program that pays for health care for people with limited income. Now, what I want to mention here real quick before we get any further is this is Medicaid. Now, there's also Iowa Medicare. These are two different plans, Plan A and Plan B. Plan A is Title 18, Plan B is Title 19 of the Social Security Act. But they would both be under the same arrangements, that there's already a contract in play for those that have to pay. It already states who pays. Is a government program that pays for health care for people with limited income. So Medicare would be the same arrangement, that they pay for health care for people with certain limitations in their income. If you are assigned to a managed care organization, the state pays the managed care organization a monthly fee, referred to as a capitation fee, to manage and pay for your medical services. Nowhere in the law does it state you have to pay. In fact, in plain writing, in government documents, they say they pay, and they hire someone else and pay them a monthly fee to manage and pay your medical services. Greetings, Roz and El Bruno. Anybody else that's there, feel free to make comments, compliments, concerns, or complaints in the chat. Anything you wish. And then it goes on to say, Iowa Medicare covers a variety of services, including but not limited to primary care, institutional care, hospitalizations, prescription drugs, case management, and waiver services. So before we go further, let's check out capitation fee. What is capitation? And it simply says capitation is the payment of a fee or grant to a doctor, school, or other person or body providing services to a number of people, such as the amount paid is determined by the number of patients, students, or customers. Capitation fee. Customer, the patient. To help pay for these services, every state must have a Medicaid estate recovery program. That's what I've been saying. They're the ones that state it. And it's operated through the Health and Human Services, which is the establishment of the exclusive vital statistics jurisdiction related to the, or attached by and through the name and enumeration at birth. When you receive Medicaid benefits, which includes capitation fees paid to managed care organizations, even if the plan did not pay for any services, the state of Iowa has the right to ask for money back from your estate after your death. After your death. Nowhere does it state that they have a right to collect prior to that death. None. The state will never ask for more money back than it paid. And remember, this is in regards to estates. And that Social Security number is attached to that Medicaid estate. It is not your estate. It only has evidence. When you receive Medicaid benefits, which includes capitation fees, the state will never ask for money back, for more money back than it paid. Estate recovery laws were passed by the U.S. Congress in all 50 states. In Iowa, the estate recovery program is run by the Department of Health and Human Services. This is so in every state. There's some kind of Health and Human Services, whether they call it the department or whatever. It's related to Health and Human Services at the national level because Social Security is a national program. It says, who does estate recovery impact? Estate recovery only applies to Medicaid recipients who are age 55 or older, or are under age 55 and live in a medical facility and will probably not return home. What part of an estate can be recovered? Notice this is the lower case. That's why they've got it. This is why we have to discern what estate are we talking about. And here it says an estate includes all real property, such as your house, land, etc. Personal property, such as household goods, personal effects, cars, etc., or any other asset that you own at the time of your death. What that's implying through the language is they have no right to know what my assets are until they read my living will at the time of my death by the executor. And that would be a private viewing, not a matter of a public record. This includes items you own with someone else, such as property, trusts, and most annuities. That's what Social Security is. And retained life estates. Notice that says retained, because most people think they are the person and hand over their life estate as the living soul for not knowing any better. And as we've already indicated, at time of your death, from your estate after your death. So as already implied, it says, can repayment be delayed? Of course. It's already set to be payable on death. Medicaid repayment can be delayed if the repayment will create hardship for your family. In other words, fathers that are paying child support under Title IV-D, it's the same thing. If it creates a hardship and it's dealing with any estate, you better know what estate it's dealing with and who it's actually operating through. If that Title IV-D child support payment is managed through Health and Human Services for the welfare of mothers and children through the Social Security Act, then I'll be damned if it's going to create a hardship on me, then it's not applicable. It's payable upon death because, in fact, the welfare of mothers and children is paid by Health and Human Services through a managed care healthcare organization. It's already paid. They state they pay it. Why? General welfare is presumed because you are in hardship already. It says DHS decides on a case-by-case basis who gets a hardship. Really? Department of Human Services. This sets as an authority of the Health and Human Services. This says it's the Iowa Department of Health and Human Services. And now all of a sudden they want to say DHS. Who is DHS and what is their authority as opposed to what we've already seen? And how is it they get to decide on a case by case? Aren't I the one that gets to decide my hardship? And we'll find out later on what some of those prerequisites of hardship are, and we can relate them to a bankruptcy, and where anybody that's gone through a bankruptcy, Gray Wolf, you're on open mic, brother. How are you doing tonight?
I'm doing all right, man.
Ah, it's Melvin. What's up, brother?
Not much. What you got going? I see you getting it in.
Well, yeah, we're showing them how it's already prepaid.
Okay.
See, if you weren't here at the beginning, let me scroll up for my brother Melvin Washington. It says in the very first paragraph, Iowa Medicaid is a government program that pays for health care for people with limited income. And when we determine income, we have to be very concise about it. We do not have an income. That is a conversion. We have not actually invested as a knowledgeable investment firm. Things were converted without our knowledge. That's an unconscionable contract. So if you are assigned to a managed care organization, the state pays the managed care organization a monthly fee, referred to as a capitation fee, to manage and pay for your medical services. So we have somebody that says it's a government program that pays for health care for people with limited income. And they hire by paying a monthly fee to a second party referred to as a capitation fee to manage and pay for your medical services. This is the
So DHS is the capitation fee.
DHS as well as what is it? Custom Medicaid and Medicare services. That's
Okay.
where everybody is initially already pre-qualified for either Medicaid or Medicare as a Medicare qualified government employee. That's done at enumeration at birth through that Social Security where they assign that Social Security number. Because mom and dad are claiming to be a resident. So the
Right.
presumption is the child will be brought up in the ways of a resident rather than in the ways of the Lord. So we already have two people or two places where they say to manage and pay, and that the state pays the managed care organization because they already have a government program that pays for health care. Okay. So as we're down here, it says, can repayment be delayed? And as it states, the state will never ask for money back, more money back than it paid. If state recovery laws were passed, or excuse me, the sentence before that says, when you receive Medicaid benefits, which includes capitation fees paid to managed care organizations, even if the plan did not pay for any services, the state of Iowa has the right to ask for money back from your estate after your death. It states no other time does it state, just like it says up here. Where is it?
I wonder what it say for Mississippi.
It'll say the same thing. This is required in every state, folks. And so let's go back down here, get caught up here. It says,
Oh, wait a minute. What you saying is, so anybody I know that's pay child support, really, they only post pay that when they die.
yeah, anything related to Social Security in any way, shape, or form, as it relates to medical of any sort, which would include child support and all of that. That's general welfare for mothers and children. That's done through Social Security, a state Medicaid estate program.
Okay.
That's those arrangements, agreements that I showed you in Title 46.
Okay, cause see, I gotta find the actual fund and the trust. Cause see, they gotta. Cause see, I seen something that was real my particular interest. We got a thing back from child support, and it says that one of the tribes, civilized tribes, was the payees for the child support plan in that local area.
Yeah, see, that'd be the same thing. They're using them as giving them a capitation fee. Sounds like to me. Would have to look into it deeper.
Well,
But this is,
I looked at it. I looked at it like if they own the land, then they would be responsible for all of its subjects there.
yeah, under Environmental Protection Act, conservation easement, the whole thing. That's what I've been telling
Okay.
the people. They have a duty. See, they don't possess any land except by condemnation of its natural use for some kind of commercial purpose. That way, they can put a concrete slab on it, put up four-walled premises, and call it a commercial site. That's what a residence is. That's a commercial site, and everybody's claiming a resident. That's how they're subjecting themselves to a tax, property tax. They're saying that they're running some kind of business out of the home when they're not. There's no business records. That's a false presumption laid on the record. That's not public land. We have to redeem the land for its natural use.
Hmm.
Anyway, so we get back to this, and that's part of the necessity of life. And so we get back to this in this next sentence. Pay attention. Your family will receive a letter about estate recovery and repayment. So after your death, they're supposed to send you a letter, your family, okay? And it's going to be a letter about estate recovery and payment. That's going to be their claim to all the fees and everything in relations to a living will that has to be settled with the state before the beneficiaries can receive anything. They have to pay off all creditors, right? State's claiming to be the
Right.
creditor. Now it says your family will have 30 days. from when the letter is received to apply for a hardship.
So damn. That's the
So
last. That's the last part of the mortgage of that birth certificate. Then that's the
that's
last part.
the
Is terms of. I
that's the
get it.
only thing that's the only thing anybody has to make a claim to is hardship. I'm not educated of the legal words of art. I'm a common layman. I understand under common layman terms in Scripture, Leviticus 25 verses 23 through 25. All I can do, and the only power I have, and glory be to Him, my Redeemer. I have the power to redeem the land of my possessions, and any of my brothers might have sold off all their possessions. I have a hardship for that reason. It's a necessity of life, not a condemnation. How dare you condemn that land? Hardship exists for a person applying for the waiver when the total household income, you don't have an actual income. They can't prove it. They don't have a record of your income except a false income that you say you got from working. That's compensation. You convert, somebody's convinced you to convert the terms. You never took your paycheck and invested it in an investment scheme where they were going to go out and sell debt to make a profit. You never did such a thing. Not intentionally. And if the record shows that you did so unconscionably, and if that's the case, then you would be one of the creditors that needs to be made whole in all of those instances. The integrity of the record fails. So you have no income is less than 200% of the federal poverty level for the size of the household. And notice these are terms. Set thine house in order. The total household resources, now they're talking resources and not income, are not more than $10,000. And recovering the resources of the estate denies your family of food, clothing, shelter, or medical care that might put a person's life or health in danger. That 10,000, not more than 10,000. 10,000 what? It says here it's got a little dollar sign. Dollar signs. Dollars of what? Medicaid repayment may be delayed if you have a spouse or dependent child who is under age 21, blind or disabled at your death. So I want to question everybody. What if you're blind and or disabled during life? Greetings, John. The link's down there if you want to join, brother. And who do we have here? I'm gonna mute you, Melvin. Keith Calcott, life coach and financial advisor who can't care for himself. Yeah, chat is lit, isn't it? That's because so many people want this information. They're screaming for it because it takes knowledge and effort and comprehension. And those with the lack of comprehension think I'm up here trying to be a life coach and financial advisor, and that I have to prove to somebody that I care about myself or care for myself. I got shit to prove to you guys. Feel free to hit that link and come on up. In the meantime, we're going to get back to it. And it says, for more information, call Iowa Medicaid Member Services. That's an unincorporated association, being a Medicaid member. Unincorporated association, a partnership. You made an arrangement, an agreement. You have to go back and fix that. This is the facts. And again, this one is down in the chat section as well. I think I've got that one on a separate page, but it's the same thing. Iowa Department of Human Services, Estate Recovery frequently asked questions. What is Medicaid estate recovery? And it says, according to federal and state law, the money that the Medicaid program pays on behalf of a Medicaid recipient. Again, confirming for the third time that is a Medicaid program that pays on behalf of the Medicaid recipient. Plain writing in government document. Had I known this before, I'd have just stated my membership for the interests of the payment already established. Payable on death. Court costs. The cost of administrating the estate. Remember, I sent you those links in the Facebook comments there, Melvin, right?
Yeah.
About the administrative law judge, and he's the one administrating the estate, but he's doing through under a judicial order. A presumed judicial order. It's never been established in the records. There's no minutes of the meeting proving that name was judicially discerned to be an agent known as a resident, federal, state, or municipal officer or agent whose resident presence is deemed necessary by the board. It never happened. There's no record of it. Funeral expenses. This is the estate established, a burial trust, upon enumeration at birth so that they can pay the funeral expenses. That's what the agreement is made for. Medical bills of the last illness. Federal and state taxes can be paid prior to the estate recovery claim. Those federal and state taxes are the things we're concerned about because, again, there's no proper valid contract. It's unconscionable, again, because you are, in fact, not a federal, state, or municipal officer or agent. That's the misnomer. So the state's Medicaid claim must be satisfied before any lower class creditors or heirs receive any assets or money, as I stated before. And they're requiring them to be paid off first before the estate can be settled by an executor. Will Medicaid take the house? No, Medicaid does not take houses, cars, necessities of life. Just as in a bankruptcy, if you have 7 houses and 47 cars and all the amenities and several businesses, they'll take all those businesses and everything and settle all the accounts and leave you with a house, a car, and all the amenities thereof, so you can still get to and from your place of work. Medicaid is a potential claimant in the estate. So if Medicaid is a potential claimant in the estate, Rule 19 of Federal Rules of Civil Procedure as it relates to joinder. Required joinder of parties. A person who is subject to service of process and whose joinder will not deprive the court of subject matter jurisdiction must be joined if the party, or as a party, if in that person's absence, the court cannot accord complete relief amongst existing parties, or that person's claims, or that person claims an interest relating to the subject of the action and is so situated that disposing of the action in the person's absence may, as a practical matter, impair or impede the person's ability to protect the interest. So if some Yahoo on the lower channels misappropriates and impairs that such stuff, it would be an issue. Says pays on behalf of a Medicaid recipient who is age 55 or older or in a long-term care facility is a debt owed back to the state. See, it's the Medicaid program at the federal level that has an agreement with the state to assign a Social Security number upon enumeration at birth to the legal entity. Upon the death of the recipient, the Medicaid program contacts heirs or files a claim against the decedent's estate to seek reimbursement for the amount owed. Now here it says the Medicaid program contacts heirs or files a claim against the decedent's estate. Or files a claim against the decedent's estate. What costs will be recovered? According to federal and state law, the money that the Medicaid program pays on behalf of a Medicaid recipient who is age 55 or older or in a long-term care facility is a debt owed back to the state. Upon the death of the recipient, the Medicaid program contacts heirs or. Again, it says the same thing. Before it said it contacts the heirs. The recovery includes the full amount of capitation payments made to the managed care plan, including medical and dental, even if the plan did not pay for any services. So it's only, recovery includes the full amount of capitation payments. In other words, they can only seek the capitation payments made to the Medicare agency that they paid. According to this, that's the capitation payments. The recovery includes the full amount of capitation payments made to a managed care, so they pay the capitation fee to the managed care organization, and then upon death, they can come and recuperate those payments in that amount. That's the record, nothing else. That's what they're supposed to pay. All these other people requesting all these other payments, that's supposed to be managed and paid through the managed care organization, and they get paid a capitation fee for doing so. What assets owned by the deceased member or any interest in an asset that the member had at the moment before death are subject to recovery? Court costs, the cost of administrating the estate. So if you have it already set out in your will to have it taken care of, then they don't get to administrate it to the state courts. It's already an arrangement made in a prior agreement. This is the importance of settling the estate, transferring the title, and reversion of all rights, titles, and interests back to your private estate, which is now established through some other account, whether it be an offshore account through Buenos Aires or whatever. Funeral expenses, as we talked about before, medical bills of the last illness, federal and state taxes can be paid prior to the estate recovery claim. The state's Medicaid claim must be satisfied before any lower class creditors or heirs receive any assets and monies. Will they take the house? No. Are there circumstances for which Medicaid would not collect its claim? Waivers of the claims for spouses, disabled children, and minor children delay payment until the death of a spouse or disabled child, or until a minor child turns 21. That's those necessities of life, hardships. If there are enough assets to pay the claim when it's due, then the claim must be paid in full. Can a state recovery program waive its claim if there is a hardship? Any person who receives assets from the estate may request a hardship waiver if recovery would create a hardship. The guidelines for a hardship waiver are in the Iowa Administrative Code. Again, remember, I'm telling you, that's that independent and neutral forum known as the Judicial Officer Department, an independent and neutral forum within the United States Postal Service, comprising of the judicial officer, the administrative law judge, and the Postal Service Board of Contract Appeals. And they have their own rules of practice, their own administrative code. For income, assets, and if the heir would be deprived of food, clothing, shelter, or medical care, such as that life or health would be endangered. An heir's reduced inheritance due to recovery is not considered a hardship. Again, in other words, if your grantor, your deceased testator that grants you his estate has 7 houses and 47 cars and all the amenities, you can essentially end up, if creditors need to be paid off, with 1 house, a car, and the amenities thereof. You're provided for. You're not provided for the whole estate until creditors are paid off. So once creditors are paid off, if you're left with 3 houses, 13 cars, and the amenities thereof, and maybe a business, you get that. But if it takes everything else to pay off those creditors, they will take everything but what leaves you the necessities of life, just like a bankruptcy. The next one I got is the State of Iowa Department of Health and Human Services, Iowa Medicaid Estate Recovery, related laws. And this one says, Congress passed the Tax Equity and Fiscal Responsibility Act in 1982 as the first federal estate recovery law for Title 19, medical assistance, also known as Medicaid. Tell me, what doesn't it have to do with tax equity? Everything's a matter of equity, folks. So whatever your record shows, if I have creditors that need to be paid off and your record shows that I've diligently paid in through Social Security, FICA, and all these other things, and has accrued through the accrual method a certain sum in credits, I need to have all creditors paid off now so that I can assess whether I'm due a house and a car and the amenities thereof as a matter of necessity, or if I am actually due more than that and can create a larger estate. Some states had already been recovered, so again, it goes to nothing merely but correcting their records. And why do I have anything to do with that? And how can I assert that? Because I've been the bitch-ass fool or bitch-ass slave all my life. I've been the fucking fool that's been entering the data elements in error. And now that I know the error of my ways, I have to rightly divide the word of truth and set the record straight, creating inconsistencies and impossibilities that show there must be a new remedy. I have to create a remedy. As equity imputes an intent to fulfill an obligation, I have to learn how to contract, and that's the basics of all of this, is contract terms and conditions required to implement statutes or executive orders, commercial items, commercial services. Some states had already been recovering medical assistance through state laws for decades. Since TEFRA was not mandatory, others refused to implement a state recovery. The Budget Reconciliation Acts of 93 and 94 then mandated that states recoup medical payments from the estates of recipients. States who failed to implement an estate recovery program were to lose federal funds. So help them out and show them that there's a hardship, that if the record truly shows there's no estate, then I'll be damned, you better leave me alone. During my lifetime, too. This mandate was upheld in West Virginia versus United States 289 F3RD 281 4th Circuit in 2002. State law. In Iowa, the estate recovery program is provided under Iowa Code Section 249A.53-2. Administrative rules are found in Section 441 IAC 752.28, Section 7. Some benefits of estate recovery. Estate recovery helps reinvest money back into Medicaid program to help taxpayer dollars stretch as far as possible to provide quality services and care to its members. Helps reinvest money. I'm telling you, folks, it's an investment, and you better know what you're investing in and why and how. What's up, Mitchell? Paul proved today he uses fake names to encourage audience to call the police for him getting his feelings hurt with truth on the internet. Go take a nap, son. Your elderly girlfriend will be back in a week, and you can get back to manipulate her to sacrifice your daughter later. Paul the snitch. Yeah, I don't know what's going on with Paul, and I really don't care. I care about Paul, but yeah, like I said before, I'm rent free in his head. He still talks about me, and I don't care. I actually stopped in and laughed at him yesterday, and I guess I shouldn't have. Oh well. Anyway, back to this. Yeah, since Iowa began pursuing estate recovery in 1994, over $500 million have been reinvested back into Medicaid program. How far can estate recovery funds stretch? In state fiscal year 2023, Iowa's estate recovery unit collected approximately $39 million. In that year, this equated to care for 440 members. In a psychiatric mental institute for children, care for 447 members over age 65 in a nursing facility. Care for 735 members receiving treatment for breast and cervical cancer, or 5,814 pregnant women. Remember that spell of illness? Inpatient hospital treatment provided the first day of, and then all of a sudden during that pregnancy, where you register at the front desk for labor, and then you give birth, and the doctor registers that birth. How does estate recovery work? Again, reaffirming for the fourth time again, after the death of a person who received Medicaid and was over 55, or a resident of a long-term care, the value of their estate, if they have one, Melvin, you still there? Okay, Melvin's off somewhere. I want to ask everybody, what's your estate? This is a trick question. See, that's about all them assets. And you're not supposed to be telling people what your assets are. That's for after death. You're not supposed to be telling people your estate. You're not even supposed to be telling people your name. Sign with an X, right? See, the problem when you enter this information into that public venue, it's a presumption of this estate, if they have one. So I want to ask everybody about that birth certificate and how it proves that you have an estate. So far, it's only proof of an estate. That could have some kind of value, the value of their estate, if they have one. 18 U.S.C. 8, stamps and other representatives of value, $10,000. What species of dollar? What's the value of your estate? I urge you to look at the parable of the talents once again and understand when that term Lord's money is used versus man's money, known as mammon. That estate of person, whereas he's no respecter of persons. Does that estate really have any value, or is the true value in the other estate? And this has only got some credits built up. Is used to reimburse the Iowa Department of Health and Human Services. And again, that reimbursement is for the payment that they paid to the health or managed care organization of the monthly fee that they paid them, whether that managed care organization actually paid any services or not. This includes the cost of services that were paid out for Medicaid benefits, including capitation fees paid to managed care plan, because the managed care organization paid it. But I guarantee you they got paid for every month that it never got paid anything, or it never paid anything. How many times do you go to the doctor? Yet every month that managed medical care management, they get paid every month, whether you go to the doctor or not. Medical and dental, regardless of how much the actual services cost the managed care plan. And then they turn around and they have you fill out insurances. With what do they call them? Some kind of payment where you've got to pay a certain amount first. Why? If they're already supposed to manage and pay for it, why are you being convinced to have an insurance plan? This is what I use against the insurance guys that come and try to sell my companion another benefit. Well, if it's a benefit and Health and Human Services is the provider of that benefit, and they pay a capitation fee for a healthcare management organization to do so, why are you coming here and having her sign up to pay for a monthly fee for some kind of benefit? Sounds like you want her to pay a capitation fee when that capitation fee is already paid. At the time of the death, if the person has no assets in their estate as defined in Iowa Code 249A.532C, there is no recovery. Unlike many neighboring states, Iowa does not place liens on real estate to secure a medical assistance debt. However, like I said, if that real estate is a matter of necessity of life, They can't touch it, just like they can't in a bankruptcy. There is no recovery. It's a principle of law, equity. There need be no statute to say it. Equity exists without law. The law, in fact, is made for criminals. The law is, in fact, made for those who are out of law and cannot act in law. That's why when you have a common law marriage, you now have true in-laws. And those in-laws are, in fact, peers. All others induced and duped into some societal identification program is doing just that, been duped and induced. Who is subject to estate recovery? Iowa's estate recovery law requires HHS to be reimbursed from the estate of a person who has received benefits under Medicaid and is age 55 or older, or under age 55 and residing in a nursing facility, intermediate care facility for persons with an intellectual disability, or mental health institute, and unlikely to return home. What Medicaid cost is included in estate recovery at the time of death again. Nowhere else does it say any other time, folks. All medical assistance paid by Health and Human Services becomes a debt against the member's estate. Becomes a debt. Not until then. I hope you guys are understanding. This is plain writing in government document. The debt includes all medical assistance paid out by HHS, including fee-for-service claims, capitation rates to managed care plans, regardless of how much the actual services cost the managed care plan, and interest. Why would it include interest? Because it's an investment, like I keep telling everybody. This debt does not include Medicare cost sharing and Medicare premiums for lower income populations after January 1st, 2010. So you would have to go to the Medicare cost sharing and Medicare premiums plan to find out how that payment arrangement is made, what that agreement is. Because it's already done. Capitation rates, what are they? Capitation rates development. Categorical waivers, the medical assistance debt that comes due from the estate, not from the living soul of a deceased Medicaid member, can be waived if there is a surviving spouse or child of any age of the deceased member who has a disability or is blind, or there is a child under age of 21, deferrals of payment until death of the spouse, disabled or blind child, or the minor of child turns 21. Let's go back to this. The medical assistance debt that comes due from the estate of a deceased Medicaid member. So I ask, what if you never become a Medicaid member? This is the question people ask about the birth registration and all that. Can't you just register it yourself? Yes. The state is still going to want to create one, but you have to be able to rebut it and say that you are not a member. You did not conscionably contract to implement the statutes and executive orders, commercial items, commercial services. Nunc-pro-tunc. You did not take upon such thing, or you do not wish to, and it cannot be forced. You with this, Washington? You with this, Melvin? Melvin? I'm going to assume he's distracted still, so we're going to finish it up here, folks. I want to thank everybody for joining me. Remember, folks, do your research, understand plain writing and government document, look up 5 U.S.C. 301 and read it comprehensively and find out what I'm talking about when the minimum birth registration standards are not met. The grammatical writing in the codes and everything say that it's applicable to the Department of Defense, and I'm not a member. The record was entered in error. The integrity is in question, and we need to do a plenary review and correct things. And with that, we are finished. We are out. I'm going to check with my brother Melvin real quick. You with us yet, Melvin? No, he is not. So, with that, like usual, folks, and as always, I remind people, don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. Everything really is in plain writing. They tell you it's already done. And they're not supposed to be collecting until after you die. And that collection is supposed to come from a record wherein credits are established. And all they got to do is move them around through a little pressing of keys so they magically move one place to another digitally. What species of money? How is that money converted? And why is it that obligation is not being carried forward in credits? Full faith and credit of the United States. So remember, folks, I love you, but I don't give a rat's ass whether you love me back. That's say I don't care if you hate me. I don't care if you don't respect me. That part's on you. So may God love you and may God bless you. Have a good night. We'll see you next time.